Hello everyone and welcome. Today we're going to explore tax-related adjudications under Indian law. We'll begin by looking at how tax disputes are resolved, starting with an introduction to tax adjudication. This refers to the formal processes available to taxpayers when they disagree with decisions made by tax authorities, like assessments or penalties. Disputes typically start with the assessment officer, who might issue an order under the Income Tax Act or GST Act. If you as a taxpayer disagree with this order, you can then appeal to higher authorities. The first level of appeal after an order from the assessment officer is to the commissioner level. This is the initial appellate authority you'd approach. Depending on the type of tax, you'd appeal to the Commissioner of Income Tax Appeals for income tax disputes, or the Commissioner of Customs, Excise and Service Tax Appeals for indirect tax matters. Typically, an appeal to the commissioner must be filed within 30 days. If you're not satisfied with the commissioner's decision, the next step is to file an appeal with the Appellate Tribunal. For income tax disputes, this brings us to the Income Tax Appellate Tribunal, or ITAT. This is a higher level of adjudication, specifically for income tax matters, acting as a crucial body for taxpayers to appeal commissioner orders. The ITAT is constituted by the central government and includes both judicial members and accountant members. To qualify as a judicial member, you need at least 10 years of experience in a judicial office, or 3 years in a higher grade of the Indian Legal Service, or 10 years as an advocate. For an accountant member, the requirements include 10 years of experience as a chartered accountant, or experience as an additional commissioner of income tax, or higher within the Indian Income Tax Service, Group A. Key appointments within the ITAT include the chairman, appointed by the central government, who must have at least 7 years of service as a judicial or accountant member. Senior vice presidents and vice presidents are also appointed by the central government and can delegate powers. While the main bench is in Mumbai, other benches are located in major cities like Kolkata, Delhi, and Chennai. When it comes to procedures, an ITAT bench is typically formed by 1 judicial member and 1 accountant member. However, for appeals where the total income computed by the assessing officer is not more than 15 lakh Indian rupees, a single member can constitute the bench. For appeals exceeding 15 lakh Indian rupees, at least 2 members are required. An assessee must file an appeal with the ITAT within 60 days of receiving the commissioner's order. Interestingly, the principal commissioner or commissioner can also appeal to the ITAT. There are specific fees for filing appeals with the ITAT, depending on the assessed income. For income up to 1 lakh Indian rupees, it's 500 Indian rupees. Between 1 lakh Indian rupees and 2 lakh Indian rupees, it's 1,500 Indian rupees. For income over 2 lakh Indian rupees, it's 1% of the assessed income or 10,000 Indian rupees, whichever is less. For other appeals, such as against penalty orders, the fee is 500 Indian rupees. Many orders from the principal commissioner or commissioner are appealable, including those related to penalties, registration of charitable trusts, and rectification orders. The tribunal also has the power to rectify any mistake apparent from the record within 6 months of the order, provided parties are given notice and an opportunity to be heard. The ITAT holds powers similar to income tax authorities and a civil court, and its proceedings are considered judicial. While the ITAT's decision on facts is final, if a question of law arises from the order, a party may appeal to the High Court. Moving to indirect taxes, we have the Customs, Excise and Service Tax Appellate Tribunal, or CESTAT. This tribunal handles indirect tax disputes and was established under the Customs Act of 1962. CESTAT has 1 principal bench and 8 regional benches. It continues to function for older cases and certain new cases related to customs, tobacco, alcohol, and petroleum products. Each bench typically comprises 1 judicial member and 1 technical member. For qualifications, a judicial member needs 10 years of experience in a judicial office, or 3 years in the Indian Legal Services, or 10 years as an advocate. Technical members, previously similar to IRS Group A Commissioner, now require an additional condition of 25 years of service. The president of CESTAT could be a high court judge or one of the tribunal members. CESTAT has the discretion to refuse an appeal if the dispute amount is 50,000 Indian rupees or less. Previously, Minimum filing fees were 1,000 Indian rupees and maximum were 10,000 Indian rupees. An order for rectification of errors used to be passed within 6 months, and the recommendatory time limit for appeal disposal was 3 years. Now let's look at the newly created GST Appellate Tribunal, or GSTAT, which handles GST-related appeals. It's often considered a refined version of CESTAT and is established under the CGST Act. GSTAT will have one principal bench and significantly more state benches, specifically 31, reflecting the shift of cases from earlier VAT tribunals to GST. Each GSTAT bench will typically have 4 members, 2 judicial members and 2 technical members, though a bench can also consist of 1 judicial and 1 technical member. For qualifications, a judicial member must be a high court judge or a district judge. Technical members, both central and state, have similar qualifications to IRS Group A Commissioner or Principal Commissioner, with the additional condition of 25 years of service. The president of GSTAT must be a Supreme Court judge or a Chief Justice of a High Court, a higher qualification than for CESTAT. The vice president must be the senior-most judicial member. Similar to CESTAT, GSTAT may refuse to admit an appeal if the case involves a dispute amount of 50,000 Indian rupees or less. Regarding fees for filing, the minimum has increased to 5,000 Indian rupees and the maximum to 25,000 Indian rupees under CGST law. With the same fees applying under SGST law, the effective minimum fees are 10,000 Indian rupees and maximum 50,000 Indian rupees. There are no fees for rectification of errors, and an order regarding a mistake is expected within 3 months. The recommendatory time limit for disposal of an appeal with GSTAT has been significantly reduced to just 1 year. Let's briefly summarize some key differences between CESTAT and GSTAT. CESTAT was established under the Customs Act, while GSTAT is under the CGST Act. CESTAT has 1 principal and 8 regional benches, whereas GSTAT will have 1 principal and 31 state benches. CESTAT benches typically have 1 judicial and 1 technical member, while GSTAT benches usually have 2 judicial and 2 technical members, though they can also operate with 1 of each. The qualifications for judicial members are higher for GSTAT, requiring high court or district judges, compared to 10 years of judicial experience for CESTAT. Similarly, the president of GSTAT must be a Supreme Court judge or High Court Chief Justice, a higher standard than for CESTAT. The vice president of GSTAT must be the senior-most judicial member, which isn't a specific requirement for CESTAT. While both tribunals have discretion to refuse appeals under 50,000 Indian rupees, their filing fees differ substantially. CESTAT's fees ranged from 1,000 Indian rupees to 10,000 Indian rupees, but GSTAT's are higher, starting from 5,000 Indian rupees up to 25,000 Indian rupees per act, effectively doubling when SGST is included. Also, there are no fees for rectification in GSTAT, compared to 500 Indian rupees for CESTAT. Finally, the time for rectification orders is shorter for GSTAT at 3 months versus 6 months for CESTAT, and the recommended appeal disposal time is much quicker at 1 year for GSTAT compared to 3 years for CESTAT. Finally, let's look at higher adjudication, specifically the High Court. Taxpayers can approach the High Court in cases involving constitutional or procedural irregularities by invoking Article 226 of the Constitution through writ petitions. This is typically done for questions of law, especially concerning the constitutionality of a provision or a breach of natural justice, often after a decision from the ITAT on a point of law. If needed, a writ appeal can be filed before a division bench of the same High Court, providing a further level of review for certain cases. In conclusion, Indian tax law offers a structured, layered system for resolving disputes. This journey typically starts with the assessment officer, moves to the commissioner, appeals, then to the specialized appellate tribunals like ITAT, CESTAT, and GSTAT, and finally, to the high courts. For taxpayers, it's crucial to understand where to appeal based on the type of tax and the stage of the dispute. Knowledge of procedural differences such as fees, time limits, and bench constitution is essential. The importance of jurisdiction, proper documentation, and adhering to limitation periods cannot be overstated in tax litigation. This comprehensive system is designed to provide taxpayers with clear mechanisms to challenge decisions and seek redressal for their grievances. Thank you for joining.